So welcome everybody. I think more people will join because we had more than, I think, 100 registrations. So just to say how happy and honored the Brussels Privacy Hub is today to launch this new event series, Data Protection in the World. I am Gianclaudio Malgieri. I am the co-director of the Brussels Privacy Hub, together with the Professor Christopher Kuhner. He also says hi. So just one word about how we decided to design this new series. So basically, of course, the data protection rights and duties in the world are changing a lot. We decided, and for we, I mean Chris Kuhner and I, Paul Dirt, but also Vincenzo Tiani, our program coordinator. Thanks to Vincenzo, thanks also to Ashwini Kumar, who helped us to set this first event. So we decided to focus on how data protection regulations in the world are changing. The Brussels impact, the Brussels effect has had its first fruits. If you think at when the GDPR was approved, how was the world situation in terms of data protection, how much it has changed. Just a few days ago, we heard that maybe there's a new agreement for the Privacy Shield with US. Who knows if Max Schrems will like this version. Great big players in the world economy, like India and China, are approving or approved new piece of legislation on data protection, quite unexpected in terms of depth. And then Mediterranean countries, South American countries. And also it would be nice to see how the international crisis can impact the global data protection in the world. So just in few words, this is not data transfer today. This event series is about data transfer tomorrow. How this, and that's why we have also a European Commission representative. So just to say, I'm very honored to have this incredible panel. I think we have literally the best people in the world to talk about this topic. I'm not exaggerating, but I think this represents a bit, at least from our perspective. I have many questions, but I will mute, I will listen, I will learn. So Vincenzo, the floor is yours to introduce our speakers. Thank you very much.
Thank you, Gianclaudio. I definitely share your enthusiasm today for our speakers. I just want to start with some technical warnings. So the event is recorded. So if you want to go on camera and mic, you are aware that you will be also on our recorded video. And you can, in the meanwhile, we will have the Q&A in an hour, so at the end, mostly at 3 p.m. But you can raise your hand and you can start already, drafting your questions and so on. So we will take all the questions at the end. So let me start with the introduction of our special guest, Dr. Amar Patnaik. He's a member of the upper house of the Parliament of India and of the Joint Parliamentary Committee on Personal Data Protection and the Finance Committee. Ivana Bartoletti, Chief Privacy Officer at WIPRO, Visiting Policy Fellow at Oxford University, author of An Artificial Revolution on Power, Politics and AI. Mr. Bruno Gencarelli, Deputy to the Director for Fundamental Rights and Rule of Law and Head of Unit of the International Data Flows and Data Protection and Digi Justice and Consumers at European Commission. And Malavika Jayaram, Executive Director at Digital Asia Lab, Faculty Associate at the Berkham Klein Center for Internet and Society at Harvard. So as Gianclaudio said, we are really excited to have you here and to explore data protection in India. So I will start with a really short introduction because I will give the floor soon to Dr. Amar Patnaik to explore what India is doing on data protection. So India, the constitution of India is governed by the rule of law, stipulated the country is governed by the rule of law. India signed some international conventions like Universal Declaration on Human Rights that contemplate the right to privacy. Anyway, in 2017, so there is no right to privacy in the Constitution, but in 2017, there was this judgment from the Supreme Court called, again, I I apologize in advance for my Indian. Puttaswamy versus Union of India decision of the Supreme Court, where the court explicitly acknowledged the right to privacy as a fundamental right, and extended also this right to non-citizen. That means that it would be a question also for Mr. Giancarelli. It means that even European data subjects could potentially raise judicial claims against an infringement of Indian authorities. It's not, there are already some laws, the Information Technology Act that was published in 2000 that contemplates, some safeguards for privacy, but these safeguards are not extended to the government. So as you can imagine, the fact that there are many exceptions from the government for security, national security reasons could be an issue, especially from a European perspective. In 2011, there was the India installed the centralized monitoring system that gave the powers to Indian government to intercept communication in a situation of public emergency. And so we already have some laws, but we can see clearly that there are some issues from a European perspective. There's also the Aadhaar Act. Again, apologize for my Indian, that established some rules on biometric identification, again with some exemptions for the Indian government. And then in 2018, so very recently, there was this draft of the Privacy Data Protection Bill that then was extended also from just personal data to all kind of data, if I'm not mistaken. That, of course, will raise some questions that we'll discuss with Ms. Bartoletti and Ms. Yavairan. So I don't want to, waste your time, and I will give the floor to Dr. Amar Patnaik with my first question. So I would like to ask you to tell us about the genesis of the main innovation of the Privacy Data Protection Bill, or the data bill. I don't know what is the official name right now. And I would like to know if you've been inspired and how much you've been inspired by the GDPR. And what are the main innovations, the main points, the main points of strength and weaknesses that you see in this bill? Thank you.
Thank you so much, everyone here, all the members of the panel and all the to these deliberations. Great initiative indeed by the Brussels Privacy Hub. Really great, because these are the forum in which we get to know what's happening across the globe. Because my prediction is that time will not be too far when we need to have, I already spoken about in our parliamentary committees, that time would not be too far when a global order has to set in as far as privacy is concerned, because there will be cross-border data flows. The world would be moving towards transactions, more transactions over the digital space. The digital growth of digital economy is happening all around the world thanks to the pandemic. It's also happening in rural areas, which was earlier not as much. In India, for example, there's been 100% increase in digital transactions in the rural areas, particularly during the pandemic, as all of us know, that there was no other option available. So that's why I think these kind of initiatives are very important, because when the G7 or the G23 or whoever sits down, the entire world order has to evolve over the issue of privacy of data. And as you said very correctly, that the Universal Declaration of Human Rights, if it draws inspiration from there, then there has to be a universality about the privacy notion and the protection of privacy of the data principles or citizens, as different countries call it differently. So the genesis of this law in India in 2017, as you said, was the Puttaswamy judgment of the Honorable Supreme Court, where they interpreted the existing fundamental rights of Indians, and as you said very correctly, it says that our fundamental rights in the Constitution are guaranteed to everyone, including non-citizens, and therefore they interpret. What I'm going to speak now relating to privacy is actually applicable to Indian citizens as well as people who are in India. They may not be citizens. The Supreme Court interpreted an existing right to life, fundamental right under Article 21 of the Indian Constitution to say, to read meaning, to say that privacy is to be read into the right to life provision and treated at par as essential to have a right to life, and therefore, from that particular day, the right to privacy, and they have Supreme Court has very categorically stated right to informational privacy is a part of the fundamental rights of everyone in India. While saying so, they not only interpreted Article 21 of the Constitution, which is a part of our fundamental rights, they even interpreted Article 19, freedom of expression, to say that privacy also forms a part of that particular fundamental right. Article 20 also forms a part of that fundamental right. So they have really given a broad kind of the broadest possible shape and conception and meaning to this term privacy, and individuals' right to have that right, as a part of their right to life. And more importantly, since in our Constitution, there is also a fundamental right that any fundamental right is justiciable in a constitutional court of law. So if there is an infringement of right at any stage by anyone, then the individual can approach the court. So we can understand that there has been a paradigmatic shift that happened just in 1 year. And the genesis, as you said, is about Aadhaar. Aadhaar is a social security ecosystem that the government had established. They wanted to use the data, biometric data and other things which have been stored in these databases for the purpose of public policy. After Puttaswamy 1 and Puttaswamy 2, and that happened in 2017 in close succession. In 1, they first said that it is a fundamental right, and in 2, they laid down the principles of that privacy, and they very categorically stated that these principles of ensuring citizens of individuals' privacy should be guided by four factors. One is it should be backed by law, and therefore the law now the bill has been introduced. It should be the principle of proportionality should be observed. That is, whenever there is an infringement of this right, it should be proportionate, it should be necessary, and it should be reasonable. These were the principles that were set out. The second judgment went further to give a particular framework, and it said that it should have purpose limitation, it should have collection limitation, it should have storage limitation, it should maintain the quality, and it also has to be accountable. Accountability also is a part. So this is the framework in the judgment of the Supreme Court. And the Supreme Court did also discuss about non-personal data, because they realized that data is the new oil, and therefore the use of data by governments for delivering public services or for growth of a digital economy is equally important, and therefore that balance has to be maintained. People ask me this question several times, that whether this balance, because as you know, it can't be very objective, there is always an element of subjectivity. So whether this balance will be tilted more towards the fundamental right of privacy or towards digital economy. This is very important because in subsequent kind of judgments that I foresee would be coming from the court would invariably, by the constitutional courts in India, they would have to invariably settle in favor of protecting the fundamental right of the citizen because it has now been declared as a fundamental right. Now, the bill initially, which was introduced in December, of course, it went through the process. There was a committee. There was a B.N. Sri Krishna committee. Is a judge, former judge of the Supreme Court himself. So there was a committee set up to draft a bill, which was called the Personal Data Protection Bill. Then it came before the Joint Parliamentary Committee. It was introduced in our lower house, came before the Joint Parliamentary Committee, consisting of members from all political parties, from the lower house and the upper house, in 2019 December, and I was a member of that committee. And despite, I must tell this and place it on record, the first wave of the pandemic hit us, and we had the first national lockdown on 24th of March. The chairman of our committee, who is currently a minister, she fell down within the first wave itself, in terms of she got COVID infected, so we had to delay the proceedings, but we sat through I think the entire 19 and 20 until December 2020, despite the second wave, despite the first wave. I think the widest consultation possible with all stakeholders, governments, big tech companies, social media platforms, the e-commerce platforms, universities, students, law universities, everything, almost everyone was consulted, except I think this is one drawback on which I've given a dissent note, is that they didn't involve the states. We call them states. Some of you may be calling them as provinces, because India is a large country. The governance is at 3 stages: the national government, at the subnational government are the states, and each state, for example, would be the size of a country in Europe. So you can imagine the size, the complexity of ensuring this privacy and legislating and making a law to ensure citizens or individuals' privacy. And then there is a third tier, which is the local self-governments, which is constitutionally introduced in the 73rd and 74th Amendment of the Constitution, Indian Constitution in 92. So these 2 tiers were not consulted, and I think that I'll talk about it a little later. So this is how the bill came up. The consultations were very wide. The number of sittings in the parliament has probably not been done for any other bill, and clause by clause, what generally happens is that in our parliamentary discussions, the government side talks about the important amendments, and there is a discussion there. But here we decided to go right from clause 1 till clause 98. Introduced a new clause, so it has now become clause 99, and there are 14 chapters over there. The chapters are broadly in terms of the chapter 1 is about application. You can see there's a structure in it. Application. Chapter 2 is about obligations of the data fiduciary. Data fiduciary is the term that we are using in our bill, which is not used in the GDPR, where they use the word, I think, controller. And then data fiduciary is the one who collects data. So a consent manager is also a data fiduciary. Anybody who collects data is a data fiduciary. And the choice of the word fiduciary is simply because of the fact that there is this very important thing about maintaining the trust between the data principal and the grounds for processing of personal data without consent. The next chapter is personal data of children, how to handle it. Then the next one is rights of data principles, right to be forgotten, right for erasure. Transparency and accountability measures, privacy by design and all are a part of that particular chapter. Then there is a restriction. This is something not there in the EU GDPR. That is the restriction and transfer of personal data outside India, what some people call it as data localization. When people ask questions, I'll answer that. I'm just trying to tell you how the bill is structured. Then the next one were the exemptions. So the exemptions, I talked about a chapter which says that the right of the data principal, data fiduciary is to process data without consent. It is a consent-based framework. For everything, you have to take consent of the data principal. But then there are exemptions where even that consent is not required. And that, of course, as you mentioned, is for the governments. We will examine whether those consents are very narrow or very broad. So this is the consent chapter. Then there is the data protection authority itself. What would be its power, composition, selection, how it will function, how it will work with separate sectoral regulators. There are sectoral regulators. That's the Reserve Bank of India. It's a data fiduciary in the financial sector. The Competition Commission, the Antitrust Commission of India, that's also a sectoral regulator. The Telecom Regulatory Authority of India, the Health Authorities of India. So this chapter talks about what the DPA's functions would be and what its constitution would be. Then the next chapter is on penalties and compensation, followed by another chapter on the appellate tribunal, that is on the orders of the DPA. There is another body sitting to listen to the appeals. Then there is a chapter on the finance, accounts, and audit, and then there is a chapter on offences. Some of them, there is one single clause, I think, which gives criminality to some of these re-identification by any actor from the data available, from a metadata, let's say, available, infer data available to the data principles, so offenses. And the last one is miscellaneous. So there are 14 chapters over there. This is the broad, and as you said, in our Supreme Court judgment itself, a heavy reliance has been placed on the EU GDPR. And EU GDPR, therefore, in 2018 has formed the basis and therefore the consent framework, I thought. And that is how the committee has also met. But once we sat down and discussed in the Joint Parliamentary Committee, we decided that it is very difficult to completely compartmentalize personal data and non-personal data. Simultaneously, the government had set up a separate committee on non-personal data who gave out their reports and classified non-personal data differently as private data, community data, and public data. There's a different classification over there, but it is treating data as an asset in simple terms. And so we thought that it is very difficult to completely separate them out. And if you have two separate regulators, then there will be turf wars, because there will be questions as to who at whose end, whose level the data re-identification has taken place. So complaints, then, if a person has complained to X regulator, the DPA, then he might say, you go to the non-DPA regulator. So we kept everything under one regulator, on one act. We have renamed, our suggestion has been to rename it as the Data Protection Authority, not Personal Data Protection. And the personal data protection, as I mentioned, 14 chapters are there. One clause has been left so that if the government later on comes out with a regulation for the non-personal data in a light touch kind of manner, because I'm convinced that the non-personal data has to have extremely light touch regulation, then it can be fitted in over there. And if the government chooses not to have any regulation and have rules rather, then that can also happen. So, but then we wanted to give a framework which is for ease of administration, and the citizens not really having to run from pillar to post or from different authorities. The second point was also there that there are mixed data packets, mixed data sets where non-personal and personal will be there. So, and many inferred data could have also both elements. So to decide at some point of time as to who is responsible for this, that is whether or which data is responsible. Is it a non-personal data, in which case it can be ignored, and if it is a personal data, then there are offenses and penalties. So handling mixed data sets would be a problem, and therefore we thought that it would be personal data protection bill itself. That's what we have recommended. The current stage is that government has not yet reintroduced the bill after considering the recommendations of the Joint Parliamentary Committee. We expect it to be done in this session, in the next couple of weeks, or maybe in the next session. One hears that there are a lot of complaints because people want the non-personal data to be completely separated out. Of course, the committee felt that if it is a part of the one thing, then it will be better. I will share my views later on that. And then the last aspect is that in the meanwhile, you mentioned about the intermediary guidelines, you mentioned about other things. So they had to be brought in because of the, some kind of controversy that we had with the Twitter and Facebooks, and we ensured with the intermediary guidelines came with prescriptions as to have localized representatives and within 72 hours to bring down content. Now, these are also there in the bill. So I think what the government did, that since the bill had not been introduced, in order to marry the things together, because they had to come out very quickly with this from demand from the MPs and everybody else. So they have kept the structure, I think, intact, but they have brought it in the form of a rule. And once this act comes, the rules will be subsumed there, because act anyway will supersede the rules as per law. The other thing, very briefly, I have mentioned in my dissent note, as I said, is that there's a need for state-level data protection authorities, just like we have the Consumer Protection Act. There are state-level authorities, or Right to Information Act. There are state-level authorities in India, because otherwise it becomes one big behemoth organization which can't really handle complaints. And then and most importantly, I must tell you this, that there are still data, huge amount of data collected at the third tier of government, which is manual. And when the Supreme Court says that informational privacy is a fundamental right, it doesn't say that only digital information. It means even manual data. And therefore, I think one national level organization will be too difficult to administer the act. And therefore, I have given a dissent note that. I also have given a dissent note on the fact that the exemptions given to government are too broad, and it is not in line with the Supreme Court's judgment. And there are some public order, for example, is actually what we have in the state list. The laws to be made as far as public order is concerned can only be made by the state, not by the center. But it is there mentioned in section 35 of the act, and therefore that's a dissent note I have given. And then lastly, there is a feeling in some quarters that there is a heavy compliance cost that is going to be there for startups and for micro, small sector enterprises because of this consent heavy provision. But what people do not know, which I can probably share now that the bill has been, now the report has been submitted in Parliament, that we have provided for carve-outs. And those carve-outs, that is regulatory sandbox and innovation sandbox, have been additionally added by the committee in some of those provisions, the details of which I can't reveal, but I can only say that to reduce this compliance cost. So this is how the situation is. I will field questions after this. Sorry for taking some more time.
Thank you very much for this wide introduction to the world of data protection in India. I will jump to Ms. Bartoletti. So you're a chief global privacy officer in a multinational company in India. So for sure you're closely watching and the evolution of this discussion. I would like to ask you, as from the private side of the discussion, what do you think this data protection bill will bring to the table for companies? Do you think, as it was in Europe, many companies will see this regulation as this bill as let's say more bureaucracy, or learning from the GDPR lesson, they think that it could be a leverage for their business to gain the trust of people, of citizens, the clients? And lastly, what do you think about this idea to merge personal data and non-personal data in the same bill? Since what I've read from some papers is that actually if you combine all this data, it means that there is less incentive to anonymize data. Anonymization of data is a way to protect data. It's a security tool. But if all the data are treated the same, perhaps there's no no leverage, there's no intention to do it. So if you can give us your view on that would be great. Thank you.
Thank you so much, and absolutely brilliant to be on this panel. And just looking at Dr. Amar Patnaik, I mean, it's a great opportunity to be on the panel with you, and hope you'll forgive me if I make the most of this opportunity in this conversation. And obviously, I mean, having both Bruno and and Dr. Patnaik makes me think about how wonderful my life as Global Chief Privacy Officer Wipro would be if we had the one most wonderful outcome after all this, and smooth data sharing across the globe, which is something that would really help. And I share Dr. Amar Patnaik idea that yes, I mean, having obviously regional, national legislation is absolutely important, but in the globalized world we live in, we have to aim for global consensus around all this. So as you can imagine, this is an issue that is very close to my heart. Working for a company of over 230,000 experts across the globe, 67 countries, a sort of an organization of designers, technologists, and business leaders, working on artificial intelligence, digital transformation, cybersecurity. Obviously, for us and for me as in my role, what is happening in India right now is absolutely crucial and important. And I think it builds on 3 trends. And this is to respond, Vincenzo, to your first question. The first trend is it built, and Dr. Amar Patnaik, do correct me if I'm wrong, but it built on India as a country and how far and where India is at the moment. I mean, we are talking about a country with 700 million internet users. I mean, we're talking about a country where IT and IT-enabled services companies account for 40% of India exports. Companies like mine and like others, they play a huge part in the economy. And also, I do believe that it comes from sort of the need to make the most as a country, as a nation, of the benefits and the dividends of digitization and all of that. And it also built on other trends which we've seen globally, namely the fact that privacy is becoming more of a concern globally. Consumer trust is becoming more and more important, and privacy is more and more a threat between different sets of legislation, you know, and from cybersecurity to digital to market competition and all of that. Obviously, Vincenzo, yes, obviously the new legislation in India, when the time will come, will have 2 years before it becomes enforceable. It will place responsibility on companies. However, one thing I would want to say is that as I mentioned earlier, privacy in India is fundamental right. Organizations in India, as we said, you know, the IT and IT-enabled services really account for 40% of India exports. It means that companies serve audiences and customers worldwide. That means that a lot of companies have embraced the legislation that is in Europe or in other parts of the world. So there is a different level there is a solid level of understanding around privacy. And there are a couple of things that I really wanted to mention that I think are very important. As you can all imagine, I spend a lot of my time as a chief privacy officer working with organizations globally on, for example, issues around global data transfers and post-assurance too, and all of that, as a lot of you do. There are some elements that I think are really, really important, and where in navigating the next months around with this legislation, it'd be really important to address. And I think the issues, for example, around data localization are issues that are. I mean, it's a trend globally. I mean, we've seen this in Europe. We've seen, I mean, importance is of data localization is growing, and it has to be said that in India, of the 10 most accessed websites in India, 8 are owned by US entities. So there are complexities around the issue of data localizations that come from India that need to be taken into account, and then I also personally completely embrace. But I do think it's important to find a good balance between the different reasons for data localization, security, privacy, wanted to give the economy a boost, which is understandable, the bargaining power, and it's for example, you know, when it comes to the economic boost that the country can have from localization, that is particularly important and relevant in India. You know, if I think about the cloud industry in India, for example, we are going from, you know, sort of a 50 billion industry in 2020, projected to grow to almost 140 billion by 2025. So, I mean, it's something that obviously India wants to take advantage of, and localization does play a part in this. However, you know, it's really important, and I think, you know, WIPRO with NASCOM and other organizations, we make this point quite clearly. You know, it's really important to balance that with the need for companies to share data, with the need for companies to be able to continue to be able to share information and data into, especially companies like the ones that I represent here. There are other issues that I would like to see addressed. For example, I mean, Section 35 was mentioned. I think there's a lot of confusion around Section 35, Dr. Patnaik. I mean, I think things are seen as more sort of one-sided than they really are, and sometimes we forget that there is the India privacy legislation, but there is also the Telegraph Act. There is also, I mean, it's and there is, you know, there is privacy as a human right, Article 121 of the Constitution. So I mean, it's not, you know, it can't be only taken in isolation. Nevertheless, the language is probably something that can be slightly improved, and of course we do have something similar under the GDPR, but I think there is an issue with, for example, saying, does the exemption have to apply to all the activities, or can it be limited to a certain number of activities? Can that be fine-tuned to perhaps bring it more in line with GDPR, or in order to facilitate that process? I wanted to finish on the personal and non-personal data, and that is a very interesting one, because and it's a very interesting one for two reasons. I mean, the first one is from a purely business perspective. I do believe that there is a point that needs to be made in relation to the complexity that may bring for organizations. So, for example, if non-personal data breaches then overlap with reporting of sort of cybersecurity incidents under the Aadhaar Act, or for example, whether there is a point that can be made in relation to sort of really prioritizing getting a personal data protection law enacted, and then build a framework on the regulation and the right to regulatory toolkit. And I think businesses have been feeling slightly, a lot of organizations have been feeling a bit anxious about this, and about including non-personal data. And I do share some of these concerns in terms of for sort of a business perspective. And also one of the other concerns that often emerges is how the requirement of sharing non-personal data for sort of policy purposes applies to all data fiduciaries and data processors without distinctions, and how this could lead to complex outcomes and concerns. So these are some of the concerns that we pick up, and I've heard, and we've discussed with NASCOM and other organizations. Nevertheless, I do have I do think that there is something really important there in relation to bringing personal and non-personal data together, and this is more of a sort of a personal consideration here, and that is the fact that Dr. Patnaik is right. You know, that the demarcation between personal and non-personal data is increasingly difficult. And there are a lot of considerations that we are having in, and I'm thinking here as sort of someone who spent, you know, Oxford University around whether individual privacy is sufficient, you know, whether we need to move towards something which is more sort of group related or relational, or because in the age we live in, it's more difficult to demarcate between the two. And I think and I think having initiated sort of this sort of bringing personal and non-personal data together is something interesting that requires consideration and thought. From a business standpoint, I do understand the complexity. Nevertheless, from a sort of more academic and angle, I do think it's a really interesting turn, and something that we are seeing, that I do see as important and necessary. I'll stop here for now.
Thank you, Ivana. Then I'll go to Mr. Giancarelli. I would like to, going through the data protection bill, I've seen many, the GDPR is 4 to 6 years old, let's say 6 years old almost. And I think that the Indian Parliament and the government added some innovation compared to the GDPR, like sandboxes, which now we are seeing in the proposal for an Artificial Intelligence Act. Explicit prohibition on profiling children, which is not so explicit in the GDPR, even if we know that there are several indications on that, on consent and so on. The possibility to nominate legal heirs, that's something new. Won't change everything, but it's still interesting actually. And identification of significant data fiduciaries, those controllers who process large amount of data, have a high turnover, and could put data principal at risk. So basically, that required for these data protection fiduciaries are required, more obligations, and that's remind me, DSA, DMA, it's something. I don't know if the Parliament, was inspired by the new pieces of legislation, European pieces of legislation. On the other hand, as I said, we have large exemptions for the states, and some doubts also expressed on the authority. I've read some remarks saying we don't think that authority is full independent, and we know how much is important that, of course, that the protection authority are fully independent. We have seen that also, I'm in Rome now normally, and in Brussels. We know even there are some discussions in Belgium, for example. So there's an issue there for sure. So I would like to, it's a really broad question, but I would like to know from you if you see, future dialogue, you see future dialogues with India for a potential adequacy decision. Do you think we are, where do you think we are with, future discussions? Thank you.
Thank you very much, and thank you very much for inviting me. Thank you to the Brussels Privacy Hub. I think this initiative on data protection in the world is an excellent one. Data protection issues are increasingly, are certainly more diverse than they were a few years ago, and increasingly global. I'm very happy to be in this discussion in India. Data protection and data flows issue are, as I said, diverse, global, and they go much beyond the EU-US relationship, as we tend too often to limit them in Europe. Let me say, before trying to answer to your question, that we very much welcome the progress in India on this legislation, and more generally the fact that India is such a key actor in the IT and digital world is joining an increasingly global trend towards on the need for rules of the game in the area of privacy, in the area of more generally ensuring responsible and accountable use of data. We also very much welcome the very open and inclusive process that led to this legislation, the discussion of this legislation in the Indian Parliament, from the consultation on the white paper on the data protection framework for India, to the consultation organized by the government on the data protection bill, to the various exchange we had with members of the Indian Parliament. Meaning the EU and the Commission, which I'm representing today, has actively engaged and with Indian stakeholders and interlocutors. We have, for instance, twice made written submissions in response to this consultation. I think the work in India and this bill which is now before the Parliament is based on impressive work, starting from the work of Justice Sri Krishna and the committee he led. And we see that and you have already described the elements of the bill, that whether we are in India or in the EU or many other parts of the world, we are trying to face both the same challenges and the same opportunities that come with data, and we can see that this bill is based on elements that are really shared increasingly by countries around the world. An overarching piece of legislation, a core set of data principles, empowering individuals with enforceable rights to gain or regain control over the data, and the creation of a supervisory authority to ensure the enforcement of such rules. We've seen and that's already a beginning of an answer to your question, that India, and we were very pleased with that, has endorsed very recently at the first EU-India Pacific Forum, a joint declaration on privacy and the protection of personal data that, in a certain sense, puts all this in a bigger picture, but also at some level of details, tries to describe what are these converging elements on which many legislation around the world and in this specific region are different legislation share, or meaning different regulatory approach share. It was very important for us that India joined that declaration. It is also remarkable if you think that this ministerial forum of the EU in the Pacific region area was the first event organized after the adoption of EU strategy on the Indo-Pacific region, and that data protection and privacy was so high on the agenda of that forum, and led to the adoption of this joint declaration, which is now open for accession by other countries. But if you look at the countries that were part of this first group, countries that are representative from the different areas of the region, from the eastern coast of Africa to the Pacific. Of course, progress in the legislative work in India on data protection are first of all important for India, for its society, for its people, for its business community. But as we have always said, they could also represent an important contribution to the strengthening of the EU-India partnership on these issues. Privacy is an area in which the EU and India share the same values. Many references have been made, for instance, to that landmark judgment of the India Supreme Court. I think that, meaning, if you compare what the India Supreme Court says about the right to privacy and what the Court of Justice, which is the highest court in Europe, said about the right to privacy, you find many commonalities. I think we have a lot to learn from each other, including on this most advanced aspect of the Indian legislation you have mentioned. We also, I think, more generally share a common approach on the need to develop a human-centric vision of the digital transformation. All this, again, to stress the importance and really the tangible benefits we could see, and that could be the result also of this legislative work in India. All this was stressed last year at one of the EU-India summit, where the leaders on both sides, Prime Minister Modi on the Indian side, Presidents Michel and von der Leyen, in their joint statement, stressed how enhancing convergence between our regulatory frameworks in ensuring a high level of protection of personal data could lead, including to a possible data adequacy decision, to a further facilitation of safe and secure cross-border data flows between us. And I don't need to explain how much this is important for trade, how much this is important for cooperation in other areas, such as cooperation between regulatory authorities, cooperation in the area of law enforcement. So it is in that, from that perspective, of strengthening our relationship, facilitating data flows, that of course we are observing, and we are looking very closely, and we are with a lot of interest to the ongoing discussions in India, including following the report of the Joint Policy Committee. And I will try to be brief, as brief as possible. There are, on substance, 3 areas that are areas that attract our interest, or raises a number of important questions for us, and they have already been mentioned to a very large extent. The role of the future data protection supervisor, data protection authority, the questions of exemption and derogation that you find in any modern system for the public sector, and last but not least, the question of data flows. In terms of the role for the future data protection authority for India, I mean, in light of our experience in Europe, and this is work in progress, but certainly one of the main lessons of the entry into force of the GDPR is the absolutely key role the governance structure, the data protection authorities play in the success or lack of success of a modern data protection framework. Data protection authorities play an important role both for citizens by providing them with an accessible point of contact to answer their queries without having to go through lengthy and costly court proceedings. We are talking here in an area where you have a lot of mundane but important for the individual queries on access, on correction, and so on. But data protection authorities are also important for business, as an independent supervisory authority can ensure consistent enforcement across cases, as well as through guidelines, ensuring therefore the uniform interpretation of the rules, and contribute, which is probably even more important, to the adaptability of the rules to evolving technological and economic conditions. A lot of the developments we are seeing now from the role of certain data processing in the context of electoral processes to cryptocurrency or other, we could not even foresee them when we proposed and adopt the GDPR. So having this constant these authorities that are that can adapt the application and the interpretation of the rules to this evolution is absolutely essential. We of course understand that the structure and the powers of the future Indian data protection authorities needs to be set in the Indian context, and you have explained already why, as the country is large, complex, with a federal structure. What we, however, note is that there are suggestions that the authority could be subject to directions from the government, and indeed this can be a challenge. It's not only in India but in Europe and in other areas. And we believe that this could undermine its legitimacy, effectiveness, and authority. The authority of the data protection authority, without playing with words, it very much depends on how much it is seen as a neutral arbitrator and which is free from external influence. This is, talking about adequacy, this is of course a central requirement of adequacy, as you've seen in a very recent adequacy that concerned Korea. We could adopt the adequacy decision only after Korea has changed its system and has ensured that the enforcement powers were entrusted with a fully independent body. The second point I wanted to mention very briefly, and Dr. Patnaik has already mentioned them to a very large extent, are this question of exemptions of government agencies from the Act. Everybody understands that any fundamental right is, or most of fundamental rights involve a balancing act, and privacy or data protection certainly does. what is important is that, and balancing out to take into consideration a number of important public interests, including in the area of law enforcement and national security. What is important is that we believe that a framework, that balance can be struck within the framework. And I think that the report of the Parliamentary Committee goes very much into that direction. It is important to avoid open-ended exceptions. Therefore, I think it's very positive that the committee recommended amendments to frame government agencies on the basis of four legitimating criteria for state interference in privacy, that were the ones that come from that famous judgment from the Supreme Court. Must be these conditions might be enshrined in law, necessary in a democratic society for legitimate aim. Interference must be proportionate, and there must be procedural guarantees against abuse. I think the committee also added that the exemption procedure must be just, fair, reasonable, and proportionate procedure. Those are, as you know, also principles that are very much at the heart of our system, and in which we are. I'm not saying that this is always easy. Sometimes we are really struggling with them, but which are absolutely key in striking that balance, and that also key, and that was a large part of the saga we just concluded to an agreement in principle with the US. What was key in finding an agreement on data flows, an arrangement on data flows with the US. And then cross-border data transfer, finally. Meaning, I think Ivana address it to a very large extent. Meaning, again, I think sometimes the Indian approach is presented on the basis of two simplistic terms. This is not about localization. This is not black and white. It's not about choosing between localization or nothing. It's about, and it's a challenge we know very well in Europe, it is finding a way, an effective way to ensure that when data is transferred, the safeguards travel with the data. And that's, of course, an essential point of any modern aspect of any modern data protection framework. First of all, to avoid that domestic requirements are circumvented just by transferring data abroad. So I think that here there's indeed, it's not always easy to understand, and a lot, I think, is left also to how the framework will be implemented, because on the one hand we see a quite restrictive approach when it comes to certain category of data, such as sensitive data or critical data, where maybe there are some restrictions that might be that might look unnecessary or disproportionate in some instances, and then silence, which I don't understand might be then filled in the context of the implementation of law when it comes to standard data, which is actually a lot of the data which is actually transferred, being non-sensitive and not critical. And here we believe, not only Europe, but I'm looking at other Asian countries, I'm looking at Latin American countries in general for transfers. They might be useful tools, such as contractual tools, for instance, that, I mean, on which the Indian legislature or the Indian government could draw inspiration to square that circle. And nobody is here saying that this is an easy square to square, but to square the circle, I think they could be an interest in looking at a slightly broader toolbox of instruments to ensure, once again, that when data travels, it travels with the necessary safeguard. So I've probably been already too long. I will stop here, but thanks again for this opportunity, and it's really a pleasure and an honor to be speaking with such co-panelists. Thank you.
Thank you, Mr. Giancarlo. Actually, I will stay here, listening to all of you for hours, because it's very, so far for, we know we all are, we like privacy, we study privacy, but of course, when it regards, countries that are different, that are far from us, it's more interesting, to see how different cultures deal with the same issue we have. And talking about different cultures and same issues, I would like to ask Miss Jairam, is it correct? I hope so. Thank you. So you're running the Digital Asia Lab. Mr. Giancarelli already mentioned the adequacy decision with South Korea. We are looking to, to the Indian proposal. Chinese government also proposed, a new bill some month ago. We can see actually some similarities. For example, this, as we already discussed a bit, this, this exception for governments, and that's something that's really different from the European perspective. I would like to know if you can enlighten us on how these exceptions are perceived in Asia, and if you know anything about if you can add something to the discussion about what's going on in Asia, so from a wider perspective concerning data protection legislations. Thank you.
Thank you. I think if I was Spanish, it could be Jairam, but Jairam works just fine. Thank you. Great to be here with all of you. It's a huge task you're giving me to speak for all of Asia. So I'll very much limit what I'm saying, but I think at a very broad level, what's really interesting, it's kind of like, they say in England that you wait at a bus stop, nothing, and then 3 buses come along at once. It's sort of a little bit like that when it comes to data protection and privacy legislation in Asia. There's been a lot of silence for a while, and then you have Pakistan, you have Sri Lanka, you have Brunei, you have China, you have India. Suddenly everybody sort of, ramped up. They've had delays because of COVID. They've had, other kinds of resource constraints. Like Thailand hasn't been able to put together its, data protection authority. They haven't got the commissioners in place. So, people have slowed down or had sort of spikes and troughs based on what's happening in the rest of the world, which has not been pretty. But I think there's so much activity now in the region. So I think that's a very interesting trend. And I think the most important thing in that is, especially with India and China, there is, I think, this sense of, is there a new game in town? Earlier, it was very much, are you following a US approach? Are you following the European approach, right? The rest of the world kind of either didn't exist or was squeezing into one of these 2 broad models, right? With give or take a few changes. And I think now with both the sort of clout of size and the amount of data that countries like India and China handle, there is this sort of explicit or implicit question of, is there now another choice in the region to say, actually, we don't have to follow either GDPR or the US approach? Could we actually align ourselves philosophically and culturally with the China model or with the India model, or cherry pick a few elements from those to sort of be more context specific? So I think that's going to be very interesting to see. I think what's also extremely interesting, but I think also if you care about privacy and geopolitics, is going to be a little unnerving and unsettling, is the extent to which geopolitical and military considerations, as well as financial considerations, will play a role in this. If you have small countries, say like a Sri Lanka, defaulting on loans from a country like China, to what extent does that then nudge Sri Lanka more towards a China-style model, right? If that's who they're in bed with financially, will that translate into that politically? And in terms of, if they see that as their key trading partner, do they care less about adequacy from a European perspective and more about, data flows intra-region with who they consider their biggest ally or supporter or funder? So I think you can't divorce a lot of these legislative developments from the politics of what's happening in Asia. So I think that's going to be incredibly important, in the same way that if they default on loans on the port and another country effectively controls their critical infrastructure and their military aspirations, does that also have a role to play in how data infrastructures and digital public goods will be dealt with. So I think, that's for me one of the most interesting literal and metaphorical battlegrounds to watch. The extent to which these models, the India or China model, will trickle down to other smaller countries in the region, and what that means for either harmonization or the lack of it within Asia. So I think for me, that's probably the most interesting space to watch. I think the other point I really want to stress, and this is kind of taking away from the more, legislative specific and section specific comments that have been so informative from the other three speakers. I think if we take a step back and look at where something like the Indian approach stems from, to me personally, I often think of it as very aligned to the environmental movement, right? You've had the rest of the world polluting, right? Actual pollution, fossil fuels and other kinds of externalities that we've seen have emanated more from the West than from poorer developing countries, the majority world countries, the global South, where we have historically polluted less. But we're now being told that we must meet the same targets that developed countries that have done most of the polluting are doing, right? So they polluted more, but because the whole world will go to hell in a handbasket, our targets are pretty much the same because we could all die, right? And I sometimes feel that in the same way that the developing countries in the global South have pushed back on, the World Bank, the IMF, and other institutions and acronyms tying aid, tying trade, trying other things to reaching certain targets or meeting certain goals in, when it comes to these kinds of aspirations around environmental and climate change goals and the SDGs, for example. I feel that the same thing is kind of creating a backlash when it comes to issues of data. There is this sense of Silicon Valley politics, capitalism have caused so many issues when it comes to how data has been treated as a resource. It's the new oil, it's the new gold, it's all of these things where historically Western companies have hoovered up a lot of data, but also they have relied on the global South on which they beta tested certain things. Social media things have been tried. Populations that don't have the ability to consent, they don't have meaningful ways of providing informed consent. They don't understand terms and conditions. They will click through anything if it means they get benefits and welfare at the end of the day. You tell them that if they have Aadhaar, they'll get their rations and food. They're not going to care if that, that algorithmic decision making will one day prevent them from getting a loan, right? So I think you have to see it against this discourse of saying the rest of the world has done data pollution for so long. So now countries like India and China think, well, we can bring in questions of local. We can talk about themes like coloniality and talk about data colonialism and the response to it. And we can talk in the language of self-determination and digital sovereignty because we've earned the right to do it when we've historically been victims of extractive policies rather than active participants with rights, liberties, and freedoms. So I think for me, the fact that to somebody in the West, why Asian countries are pushing for very collective ideas and sandboxes and seeing data as a resource. India will say, well, we might not be number one at anything else, but we're really number one in terms of population. We have an asset when it comes to the stages of development, and what can data do for us that historic gaps in governance have not, right? So I'm not in favor of it. I don't like the idea of data being treated as an asset rather than and hopes and dreams. But I'm only saying this as a way of understanding why the debates can seem very polarized when, the India Stack folks, when the, Niti Aayog folks talk about harnessing the power of big data. And equally, you have this massive backlash, except we're doing it to ourselves. It's not somebody else doing it to us, right? So I think on both sides, the people who are the techno-utopian AI for good in place, you don't have meaningful authorities, you don't have meaningful rights of access, of deletion, of erasure, of querying, of appeal. There's no point in talking about data as a collective good. So I think to the extent that the work of the JPC and the work of that have taken place with other fora, with the European Union, to the extent that they are still trying to locate the individual within this, I think that's a really important thing to keep remembering, that there is an individual behind all of these collective resources and digital assets. And of course, is when the pendulum swings between national security on one hand, or the public interest or the national interest, which might or might not be a very legitimate goal, is on the other side of the pendulum, economic imperatives to create governance frameworks, to allow for data access, data sharing, data flows, cross-border data flows, to what companies or large, where does the individual get left behind? So I think to the extent that we keep coming back to the Puttaswamy principles around transparency, around proportionality, reasonableness, all of these things, I think if you don't keep locating the individual within these frameworks, we're actually going to let down a very large percentage of the population that actually relies on data, both to enable as well as to restrict it. So I think for me, often when you have the discourse sort of in Asia, scoping and boundary management issue that we as academics and scholars and people working in government and civil society have, is to sort of disaggregate and say, you have a penumbra around privacy, you have certain data protection, goals that come from the data protection framework that can saying, no, you can't do this, no, you can't collect, no, this is not proportionate, no, this is, you have to minimize, this is not legitimate. I think you have to sort of balance these two, that privacy and the private self, the home, the castle, all of those ideas around informational self-determination, around the individual and the rights that they carry, versus the share hands. Towards this trajectory of adequacy, I think will also be a very, very interesting open question. That you can see that there is sort of a path towards that. Which could be a more context-specific thing that Asian countries might be attracted to, where they do have these collective political interests in data. So for me, I think what's happening in India and China and the extraterritorial effects, whether on a philosophical level or an actual data flows level, I think that will be sort of a very interesting thing to follow. Convergences and divergences between the India model, the China model, and the European model. It's a little outdated now. I think it was in 2020. Developments of the JPC won't be referred to explicitly. Some of the new changes that Dr. Patnaik and his team have been putting in response to the comments that they've received, I think they won't be specifically addressed. But in terms of national security, looking at it through a more nuanced of divergence. I think that paper is a very instructive thing. So I'll stop there.
So I know that Gian Claudio has a question. Yeah.
Yeah, I would have a question for economics. So you mentioned digital illiteracy, digital divide. There's a lot of digital vulnerable people under different perspectives. On the other hand, we have, as Ivana was saying, a growing market of AI and digital. According to the question is for Dr. Amar Patnaik, if the so it's just actually I'm just asking Dr. Patnaik to comment on what Malavika said. I mean, maybe Vincenzo can rapidly summarize for
what Malavika was saying. We have not lost track of the individual. Supreme Court judgment is specifically for the individual. That his right is to be protected. And therefore, I was very clear when I said all through the bill, we have maintained that if there is a decision on the balance and it is very complex to decide, then digital economy for, let's say, big data. We also have to remember that government is the biggest data fiduciary. It collects data more than anybody else, and therefore this bill is transformational in the sense it is giving right to the citizen without his consent, which was happening earlier. Not go through the same rigor of personal data as mentioned in the bill. So what we have done, suggested in the JPC, is bringing regulations under one fold. Doesn't mean that we are getting the NPD, the non-personal data, also to be following the regulations of the personal data. We have actually reduced time for legislation by having this together. Then the third thing I would respond again here is about the digital divide. Manual data is also a part of the informational privacy of the citizen. And in the definition of the subnational and sub-subnational, some states having much more serious whether not their towers are blown up and all that, but that citizen over there also enjoys, and therefore it should be easy for him to enjoy that privacy, and in case of breach and protection authority. But if you have like the consumer courts complaint, if a harm is caused. Having said all this, I would again request you to go through my reputed newspaper about data equity. I've talked about data equity, a new concept where I am saying what Malvikaji was saying precisely, that in this entire thing, what does the is generating business, which is generating wealth, is he getting any part of that wealth? Data as an asset. So I have asked this question in that article. But this is a very complex issue. But Indian model, like children, you said, and we made this distinction. Significant data fiduciary are those, so government is itself a significant data fiduciary. Then there are critical data, personal data, significant personal data. So data localization has been prescribed only strictly in the strictest sense that you can't be processing it outside India for critical personal data. And that's a very small percentage. For others, you can have a mirror of the data. In fact, I have again written an article which says that data localization should be interpreted by India, everyone in India, the policymakers is included, to be making India as the future data capital, data service capital of the world. Low cost compared to what you are getting in United States or Ireland where the root servers are there, and not as something which is a security concern. And this is what I think I mentioned in the committee, and it succeeded, and I've written about it, that we must promote data localization from a business perspective for India's good, from an economic good, not from the sense of a political good.
Thank you. I know we are running a bit out of time. Just take the question I found in the chat for Dr. Patnaik. So comparing the GDPR with the data protection bill, which is more comprehensive, and also what is the government stand on data fiduciary?
Sorry, I didn't get the question actually properly. What did it find wrong?
Yeah. So what is the government stand on data fiduciary?
Government stand in data fiduciary. Government itself is the biggest data fiduciary, and it is subjected to the Supreme Court's judgment. So that is the fine balancing that we have tried to do. And still, some of us who have given dissent to the bill, which will come up for discussion in the House, is that we still feel that the government is having a little preeminent position in enjoying exemptions. And therefore, that should be as narrow as possible, because citizens grouse against the government as far as the existing fundamental rights is mostly against government. And therefore, the government itself can't be seen to be giving this protection to the citizens. It is the Constitution now which gives this protection. And therefore, the government has to abide by this as a data fiduciary, which is again mentioned in the Constitution, reasonable restrictions under Article 19(2) relating to security and other things. So what happens is that even if we have a little more broader definition, I think the test will be against the constitutional principle already laid down, which is Article 19(2). The reasonable restrictions very narrowly defined.
Okay, thank you. I don't see any other question in the chat, so I will thank you all the panelists for being here. It was very really enlightening, really, and I think that's this occasion to share different points of view coming from different cultures is really enriching the discussion around data protection. So again, thank you. I will say our attendees that the next event on this data protection series will be on China, and we'll communicate with everyone interested the date. And I will not wrap up because there's too much to say, so we will need another half an hour. So again, thank you for coming here, and I really enjoyed the discussion, and I wish you a good day.
Thank you. Bye bye.
Thank you so much. Thank you so much to the the Brussels Privacy Hub and all the panelists present here. Great perspectives indeed. And I'm quite happy that the Joint Parliamentary Committee did discuss many of these things, and I think the consultation was good, as was mentioned by the European Union representative here, because these consultations really helped us to sharpen things and go beyond the GDPR. Of course, there are there are things which you can do better. For example, we have introduced the child separate chapter on protection of data of children. But what is the age? We have fixed the age as per our constitution, in line with our other laws, which is 18 years. But there are questions now as to why should it be 18, and my personal view that it could be actually graded because it all depends on how the data is going to be used. Then only the privacy concern will arise. In a health pandemic situation, the use of the data would be different, and therefore the necessity of getting consent or the requirement of getting consent always may not be there. May not be very difficult, may be very difficult, and therefore shouldn't be there. But in case of some other thing, it may not be required. So these kind of conflicts will be there, but I think it's an evolving law. It will keep on evolving as technology evolves, as standards of anonymization also dissipate, and new standards of anonymization come, and then anonymized data, as you see today, may not be anonymized after a month. This kind of difficulties will be encountered by, I think, all data protection authorities. So as you said very correctly, that it is the DPA which will, the independence, the functional independence, the structural independence, the functional competence of the DPA would ensure whether we are having a good implementation of the regime or a poor implementation of the regime. Thank you so much.
Thank you.
Thank you.
Thank you.